I, Sakib Rahman, Senior Lecturer at the Department of Law, North-South University, would like to welcome you all to our webinar today. It would be a pleasure for us to be able to listen to Professor Jane Kelsey, who this Friday morning has very kindly made the time to talk on the controversy over the digital trade e-commerce rules. Before we request Professor Kelsey to start, I'd like to bring to the notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off at all times. And lastly, I would like to extend my thanks on behalf of the Department of Law to all of you present here today. Now, regarding our guest speaker, Professor Jane Kelsey is one of the New Zealand's best-known critical commentators on issues of globalization and neoliberalism. She has taught at the University of Auckland since 1979, specializing in socio-legal studies, law and policy, and international economic regulation. Jane is active internationally as a researcher, analyst, advisor, and media commentator on globalization, especially the Trans-Pacific Partnership Agreement, trade in services, and investment agreements. She's an active member of a number of international coalitions of academics, trade unionists, NGOs, and social movements working for social justice. Now, before listening to Professor Kelsey, I'd like to request Professor Rizwanul, Chair of the Department of Law at North-South University, for his introductory remarks. Sir, please.
Thank you very much, Sakib. Good morning or good evening, depending on wherever you are. It's my utmost pleasure to welcome Professor Jane Kelsey to talk for us. Jane has been very kindly cooperating with us on this, and she has made time for us. So I'm very grateful to her for her time. Now, with regard to the topic that Jane would be talking this morning, digital trade, as you can see, is something that is on the rise all the time. But the digital trade rules that are being advocated by some developed countries, there can be legitimate questions about the motive for those rules. For whom are those rules? Are those rules only for some big tech companies or for the mass? And there are several legitimate questions about the contents of those rules. Are those rules really trade rules, or are those rules much deeper? Do they deal with technology as such instead of just focusing them on digital trade? And also there are legitimate questions about the developing world or least developed countries benefiting from those trade rules. And what would be the right forum for negotiating those rules? Would it be the WTO? Would it be some plurilateral agreements or multilateral agreements beyond WTO, or some bilateral trade agreements? So these issues have been very controversial in the last couple of years, and perhaps it would not be sort of stretching it too far to say that in the upcoming WTO Ministerial Conference and in other multilateral forums, this would be an issue that would be debated fiercely, that would be remain a matter of controversy for some time to come. So with that brief note, I look forward to listening to Professor Kelsey's talk, and I'm sure the audience, you are also waiting for her to speak, and I would appreciate your time in listening to Jane, and hopefully we can contribute to the discussion by raising our questions. Thank you all.
Thank you very much, sir. Now, the talk you've been eagerly waiting for. Professor Jane, whenever you're ready.
Thank you very much. And as we would say from here in New Zealand, kia ora koutou, he mihi nui kia koutou. Greetings to you, warmest greetings in particular to Professor Rizwanul Islam, and thank you to him and to the Dean and the Department of Law for inviting me to share some thoughts with you about what is probably the hot topic of the moment in the international economic law arena. And I suggested that we make the topic not so much technical about what is happening in the rules themselves, but contextualizing the current controversy around the development of trade rules to govern the digital space. And so in this short talk, I want to discuss 6 points. Firstly, stepping back from the trade issues directly, what are the challenges that governments are facing today in regulating the digital domain? Because whatever global rules are going to be developed, they have to be fit to address those challenges. And we need to work out what kind of balance is appropriate in the way that we regulate the digital domain to reflect a variety of interests and concerns. The second question is, in light of those challenges, is it appropriate to address them through trade rules? The third question, because that is what is happening, is who is setting the agenda and developing the template for global digital trade rules? And how is that influencing what is happening in the current negotiations? Fourthly, what are the development implications of this approach and this template? Fifth, if the WTO is the place where global rules are going to be developed, does it actually have any mandate to be involved in doing so? And finally, what kind of backlash are we starting to see occurring in relation to the digital trade rules, which, as Professor Rizwanul Islam said, is now looking as if it is going to be a point of very significant conflict at the 12th Ministerial Conference of the WTO in late November in Geneva. And why is that occurring? So let me start with the big picture question about what are some of the challenges that governments are facing today in regulating the digital domain? And I'm sure that these are as much questions that you're facing as they are virtually every other country in the world. If we think about the digital domain and how rapidly it is evolving, remembering that the World Wide Web was really only developed in the early 1990s in any public kind of way, we're looking at an incredibly rapid development of new technologies and new uses of those technologies, expanding every year. So we have, of course, the search engines, which are dominated globally by Google, even though there are some other search engines. We see digital marketplaces dominated in particular by Amazon, but there are others as well. We see social media having emerged, which is dominated especially by Facebook. We see content providers such as Netflix, dealing with the entertainment domain. There are new digital technologies in artificial intelligence, whether we're looking at those in the health sector, in the transportation sector, such as drones, in surveillance. We're seeing smart products that have AI embedded in them. We're seeing 3D printing. We're seeing even smart cities, entire cities being developed around the use of these new technologies. We're seeing algorithmic trading. We're seeing targeted advertising based on algorithms. And underpinning all of this, of course, we see the rise of the importance of data. Data, often described as the new oil, which has value for itself. It's now seen as a new commodity or a new asset, but also as the driver of all of those other activities. And if we think about 5 or 10 years from now, it's actually unimaginable what we will start to see. And so there is a really important question about what kind of challenges governments might face as a result of these evolving technologies. And we're already seeing a number of those emerge in regulatory debates, especially because of the oligopolistic power that what's sometimes referred to as GAFA, Google, Amazon, Facebook, Apple, and some include in that Alibaba. And the notion that there is a free and open digital space, but in fact it is largely captured by those who were the first movers, which has raised really serious issues around competition, issues around consumer protection, issues around privacy, issues around taxation and how to effectively tax activities taking place across the border. We're seeing real issues around democracy and political influence of the tech companies, but also the ways that governments are using the technologies and issues of censorship and surveillance and control. We're seeing issues about criminal activity. One of the areas I've been working on for the last 2 or 3 years has been Indigenous rights and the rights of Indigenous peoples to control data, which has huge sensitivities for them. We've seen issues of human rights violations. We also, in the legal sphere, see problems of jurisdiction when the digital companies are operating outside the national legal domain, problems of enforcement, of access to evidence and disclosure, burdens of proof, and so on. And this is just touching the very wide spectrum of issues. And so moving from that first big picture to my second question, is it appropriate to address these challenges through trade rules? And my short answer is no. There have been attempts earlier to address some of the issues around the internet in another international organization, the International Telecommunications Union, because the internet was seen as an emergent new technology out of the telecommunications space. And the ITU is interesting because it's a multi-stakeholder place. It's public. It seeks to balance a range of competing interests, commercial interests, interests about promoting innovation, interests about civil society's concerns, but also states' regulatory policy space. But the attempt to do that was blocked by the US. And that reflects a very important starting point for understanding the developments that occurred in the trade arena. In 1996, there was an upgrade of the US Telecommunications Act, which regulated the old-fashioned telcos, the old-fashioned telecommunications companies, but effectively shielded the emergent internet from regulation. And so in the US, the digital space was effectively a regulation-free zone. And the notion that there might be international rules that might start to impose regulation on the internet was something that the US was determined wouldn't happen. And so there started to be discussion about the way to protect that regulation-free zone in the international arena through a different kind of forum. And the discussions then started to turn to whether this could be dealt with in the trade rules context. And I'm going to talk a little bit about how that happened in a moment, but why might the trade context be problematic for addressing that range of challenges that I identified? Well, the obvious answer to that is that the priority in the trade context is on commercial interests. And the rules are designed predominantly to facilitate access to markets and non-discriminatory regulation in relation to commercial interests. And that makes it extremely difficult to have the kind of balanced approach that we might need when we're dealing with competition issues, or when we're dealing with consumer protection interests, or when we're dealing with protection of democratic space and so on. And what we see consistently in trade rules is that the scope of them tends to be quite broad. And the balancing elements are brought in then as exceptions or exclusions to the presumption of rules that favor the commercial interests, which means that you have an imbalance to begin with. And you have some difficulties in defining what those carve-outs and exceptions and defenses might be. And they are defined using trade law jurisprudence. And if there is a dispute, it's determined by a trade law tribunal of trade experts. And so the kind of regulatory balances that might need to be engaged with at the domestic level by governments, or that the ITU might have been looking at, are not going to be the framework within which we're going to see that addressed in the trade arena. So let me explain a little bit about how the trade rules emerged, and then I'll mention just a few of those rules so that you can get a bit of a picture. So my third question was, who is setting the agenda? And who is developing the template for global digital trade rules? And what is that starting to look like? Well, you will have gathered by now that the US has been very much the driver in the development of these rules. And we started to see them being developed incrementally in a number of the free trade agreements from the early 2000s. Initially, they were focused on what you would consider to be kind of more trade-related elements of facilitating the way that digital technology supported things like supply chains. They began to expand their scope, and in particular, when the Trans-Pacific Partnership Agreement began negotiations in early 2010, with initially 9 countries, and the US taking the lead in many of the chapters. And some of those chapters were novel. They had not existed before in that form. And the electronic commerce chapter in the TPP was one of those chapters. And as we've gone back and done more and more research on this, it's become clear that 2010 coincided with the technology lobby, the Silicon Valley lobby in the US becoming more powerful and more organized. So there were a number of different tech lobby groups that were pressurizing the US trade representative for what could be considered to be a gold standard e-commerce chapter in the agreement. That was assisted along the way by the fact that the US trade representative in charge of the e-commerce was a former president of some 23 or 24 years of the Business Software Alliance from the US. So literally the industry was negotiating these rules. And I followed these rules very closely. I was at most of the negotiating rounds. It was very clear that the negotiators of that chapter really had very little idea about digital regulation or about what the implications of the rules would be. And of course, these rules were being negotiated in secret. So there was no public text that could be analysed. And indeed, even though there were leaks of a number of other chapters, there was no leak of the text of this chapter, which made it very difficult for those of us who would be analysing texts to be able to raise what some of the issues were. And it became clear along the lines that, along the period of the negotiations, that some of these rules were going to serve the interests of the big tech companies by locking in the dominance that they already had within the international arena, and their ability to operate from hubs out into many different countries. So one of the core rules that they wanted, in fact, probably the most important rule, was to ensure that they maintained control over data. And so 2 of the rules that we see in the e-commerce template are the ability of companies to move data anywhere they want to in the world. So governments cannot require that data is held within their country rather than moved offshore. In the early agreements, you were allowed to insist that there was that the data was held in your country, as long as you allowed it also to be moved offshore so that it could be used by the tech companies as the drivers of their of the global digital ecosystem. But some of the more recent agreements say you cannot even require a copy to be held. It must all be allowed to be offshore. A complementary rule is that you can't require digital companies to use local computing facilities, including local servers. Nor can you say in which countries the data can be held on servers. And so increasingly now we're seeing, alongside tax havens, data havens, servers being set up in countries where there is complete protection for the data held on those servers to the owners of that data. And it's the companies who have mined the data who claim to own it. Another really important rule is that you cannot require a digital operator who is providing a service from offshore, whether it's a Google search engine or Facebook or Amazon or whoever, to have any local presence inside your country. And of course, that makes it very difficult for the tax system, because the tax system works on the assumption that there is a permanent establishment inside the country and you tax on the revenue. But also it makes it very difficult to subject Facebook US or Facebook Ireland to the domestic jurisdiction of your courts. Another very important rule was that governments could not require the disclosure of source codes, or more recently of algorithms. So that would make it very difficult, for example, to identify where there are improper consumer protection practices, or where SMEs are being put on page 10 of a search page for a particular item, and the search engine or Amazon's own products are all on the first 3 pages, or those who pay a premium to be there. Other new rules included not requiring technology transfer as a condition of investment in the country, or not requiring the employment of people at levels that would give them access to proprietary knowledge, which means higher skilled workers. Another of the big tech demands was that a moratorium adopted in the World Trade Organization on tariffs on e-transmissions was made permanent. And the more e-transmissions you have, especially with the growth of 3D printing, the more the customs revenue would be depleted, but also the more difficult it would be for local competitors. Now, there were exceptions that were forced into these rules, but they were all trying to claw back a bit of space. And they were all defenses that governments would have to raise, and all quite unclear. And since the TPP set the initial template, we've seen a number of other free trade agreements that have adopted those rules, especially those being promoted by Japan or Australia or New Zealand or the EU or the US. We've seen a digital economic partnership agreement between New Zealand, Singapore, and Chile that is now being promoted through APEC, the Asia Pacific Economic Cooperation Forum, and forming the basis of new negotiations in the WTO. So my fourth question is, what are the development implications of this? There is quite a lot of talk about the benefits for developing countries of e-commerce, which then immediately gets transferred over to anti-commerce rules. Now, no one is going to say that there are not potentially huge benefits for the global south when we're dealing with the emergence of these technologies. But that is a very different thing from the benefits of the kind of rules I've been describing for developing countries. And what we've started to see is in UNCTAD, for example, United Nations Conference on Trade and Development, which is supposed to be a pro-development forum. There is actually a split inside UNCTAD. There is one part of UNCTAD that is promoting e-commerce for development, including these rules, which has some funding for that project from some of the big developed country supporters of the rules. And there is another part of UNCTAD who've been doing economic projections of what the consequences of these kinds of rules are going to be for development. Not just the fiscal kinds of impacts, but the impacts on dealing with the digital divide and dealing with the challenges of digital development strategies within developing countries and how the rules are likely to pose barriers for them, including barriers for small and medium enterprises, for women, for those who the argument says will benefit from the technologies. There's also been quite a lot of focus on the problem of control of data. Because if digital development depends on the ability of countries to control data, and that data is offshore and owned by those who haven't paid for it, but who claim total control over it wherever they are holding it, it's extremely difficult for developing countries to be able to develop their own digital spaces. Likewise, if there's no technology transfer, no requirement to use local computing facilities, why are you going to invest in advanced local computing facilities if the big players can't use them, can't be required to use them? And a very serious set of questions around the permanency of those customs duties and the impacts on tax. So some countries, a number of Asian and African countries in particular, have been developing digital services taxes that seek to tax the cross-border activities, in particular in areas like advertising of the big tech players. And there is a big challenge at present by the US in what are known as Section 301 of the Trade Act investigations, where they're threatening to put trade sanctions on countries for introducing those taxes. So fifth question I asked, if this has been occurring not only in free trade agreements, bilaterally and regionally, and some of the mega regional agreements like the TPP, and there are now attempts to do this in the WTO as a set of global rules, why is this such a hot point in the WTO? Well, back in 1998, the WTO members collectively established a work program on electronic commerce. And they divided up the work that was to be done on that amongst 4 councils or bodies in the WTO. There were some trade in goods issues, there were trade in services issues, there were intellectual property rights issues, and then the Committee on Development. And this started to become quite controversial already because developed and developing countries were having discussions about how to deal with these questions and quite different agendas. And so it ended up not going anywhere. And that's part of the reason why the free trade agreements in the 2000s and then the TPP became the place for developing this template. By 2016, the US wanted to move it back into the WTO. And then there were a number of attempts. Japan was a very important player as well in trying to get the last ministerial conference in Buenos Aires to agree to negotiations on e-commerce. And that was blocked. And it was blocked in particular by India and South Africa, by the Africa group, by the least developed countries group. And there was instead a plurilateral, which means a group of countries got together and issued a joint statement saying they were going to hold talks on e-commerce with a view to negotiations. And then subsequently at the big Davos meeting, they announced they were going to begin negotiating. And there were a group of developing countries who were encouraged to be a part of this under the label of e-commerce for development. Those negotiations have been continuing largely on the basis of the TPP-style negotiations, although China is also a part of it, and China has some particular interests that it wants to defend. These documents have not been made public. So those outside the WTO haven't been able to see what's been happening except for some recent leaks. But the negotiations are taking place without a mandate in the World Trade Organization. The Secretariat is supporting them. The documents have got official numbers on them. The new Director General from Africa, woman from Africa, has indicated support for this. And that has put the developing countries who are saying, we never agreed to this in the WTO, in the position of now putting on the table, just a couple of weeks ago, a paper saying these developments on e-commerce and some others on other matters are unconstitutional in the WTO, indicating that they will fight attempts to bring them into the WTO through a back door, which is the way that the process is currently operating. And if there are attempts to do that, there's likely to end up as a dispute. So this is shaping up as a very big fight in the lead up to the November ministerial. My final point, what is happening in some of the pushback that we are seeing on this? There is increasingly strong civil society concern about the lack of balance around regulation, around the lack of a development dimension because of the nature of trade rules and the nature of these trade rules. And in individual countries, there is a growing concern between different departments of government about the ability to pursue the regulatory programs that countries are now saying is needed because of the potential constraints of the trade rules. Yet there is very little connection between those parts of government when it comes to the negotiations. The best example we've seen of that recently is the recently concluded Regional Comprehensive Economic Partnership Agreement, which is in the Asia region. And that had India, had China, had South Korea, Japan, Australia, New Zealand, and the 10 ASEAN countries. India, for reasons that weren't linked to e-commerce, withdrew before it was concluded. But China was also very concerned to ensure that there were not rules which would affect its ability to operate, especially through the likes of Alibaba, Tencent, and so on, but also that would mean it could use security exceptions where it considered that necessary. So what we saw and ASEAN countries amongst themselves were also quite divided. Indonesia, for example, was very concerned about this. And so what we saw was some of the rules, like the rules on source code, are not in RCEP. We saw that there are the ban on customs duties on e-transmissions is not permanent. It's linked to what's happening in the WTO. There is a total essential security carve-out, self-judging by countries in relation to data movement. And above all, the chapter is not enforceable. And that reflects the concerns in the Asia region about the potential implications of these trade rules, which are also reflected in the position that many of them have taken in the WTO discussions. So that is the framework that I wanted to set out, and I will now pass back for any questions or discussions.
Thank you very, very much, Kelsey. I'm sure everyone enjoyed your talk throughout. Now, there are some questions, and whenever you're ready, I'd like to place those questions so that you can entertain them.
Please.
Thank you. Well, the first question comes from the chair of the Department of Law, Professor Rizwanul. Here it is. With some developing countries signing bilateral trade agreements with developed countries, including a chapter on digital trade, do you think that even without any multilateral rules, there would be increasing pressure on developing countries to concede to the demands on having extensive rules on digital trade?
That is an exceptionally good question, and absolutely there is a serious risk. What we have been encouraging countries to do is to look at some of the precedents that have been established in other agreements that even some of the developed countries have participated in. For example, the EU-Mercosur agreement, the Latin American group of countries, that has what we call a rendezvous clause. We will come back and talk about it again at some time. In some other agreements, there has been no e-commerce chapter. In some, there has been this rendezvous clause for some specific rules, in particular, the most serious of the data transfer rules. So there are examples of agreements where even those countries have adopted cautious approaches. There are also examples where RCEP is clearly one where the chapter is not binding, is not enforceable, which under international law still means that there is an obligation, a good faith obligation to comply with it, but it's not enforceable. One of the problems, which I didn't actually mention in my talk, is that even where that's happening, some of the rules in other chapters might have a very similar effect. So we have been encouraging negotiators to look at the crossover between e-commerce and the chapters on trade and services, on financial services, on telecommunications, on investment, on government procurement, because they all involve the digital issues in ways that overlap with e-commerce. And so even if we're able to take defensive position in relation to an e-commerce chapter itself, it's critically important to be looking at the implications of those other chapters as well. And yes, strategically, the objective at present is to get countries to sign up to those agreements bilaterally or regionally. That then undercuts their ability to resist them at the multilateral level. And even if at the multilateral level, a consensus is only possible around a lower threshold of rules, they can by offering trade-offs with agriculture or something else, or textiles, seek to demand a higher level of rules in the bilaterals.
Thank you very much, Professor Kelsey. We have a question from Ms. Shaun Priya. The question is, as the e-commerce trade often takes place internationally, can the domestic laws protect the international customers?
Again, a very good question. And that's one of the reasons why there was an initial suggestion of how to address this in a forum like the International Telecommunications Union, which sought to look at how to balance the international jurisdiction with the national level jurisdiction of governments. I can't see anything happening in the ITU. What governments have now been attempting to do in specific policy areas, for example, in competition law, or I mentioned in taxation law, or in some areas of regulation, for example, alcohol regulation, which is increasingly being done through the digital platforms, not the old forms of how we used to regulate the sale and marketing of alcohol, and many other similar questions. Regulators have been grappling with what are the problems of being able to apply jurisdiction extraterritorially outside the country. If I just use the example of tax, the OECD G20 developed something called the Integrated Framework for BEPS, based erosion and profit shifting by multinationals. And the digital multinationals are experts at being able to move the revenue and profits around to minimize tax. And they tried to develop in the OECD an agreed set of rules that might allow an imputed establishment in the country by the operators based on the amount of their traffic on their sites, even if they didn't have a physical presence. And the US companies and the US itself has blocked this so far in the OECD. And as I mentioned, even has inquiries that it has investigations that it's set up unilaterally to try to punish countries who adopt this. But many countries are doing it. And so in the Asian region, India, Indonesia, both targeted by the US in these investigations, have been adopting this. And it's one of those examples, and the EU has, and a range of other countries. So the more countries that do it, the more there is the ability to resist the kind of pressures from the US. In some other areas, even the US is recognizing that disarming itself may be problematic, and those who follow the arguments, the policy arguments inside the US, there is a backlash in the US about the big tech companies. And so they have been looking at ways to possibly even force them to break up. And so in the most recent US agreement, the US-Mexico-Canada agreement, there is, in relation in particular to this provision on source codes and algorithms, an exception in relation to an investigation by regulatory authorities that require access to the source codes and the algorithms. Now that is written into the agreement itself, and so you have to be able to get the other parties to the agreement to agree to that. But I think it's going to become more standard because even some of the big countries are worrying about their own domestic jurisdiction being able to operate. So that's just a few examples in response to that question.
Thank you very much, Professor Kelsey. We have another question. Assuming that the current WTO negotiating efforts on digital trade rules is unconstitutional, is there any avenue to legally challenge it? As there is no treaty yet, possibly WTO DSP is not an option?
Yes, well, it is a space that everybody is watching what is happening in the WTO with its dispute settlement mechanism. Of course, the panel level of the WTO dispute process is still alive. Some countries are party to a side arrangement amongst themselves, but that only works if both of the parties to the dispute are part of that arrangement. I mentioned the paper that was tabled very recently by India and South Africa. And the person who asked the question and others might find that interesting to look at, because it looks fundamentally at the Marrakesh Agreement itself, the agreement establishing the World Trade Organization. And as an international organization, the WTO is only mandated to do what the agreement establishing it empowers it to do, which means that the members have to obey the rules. And the WTO agreement institutionalizes the practice of consensus decision-making amongst all the members. And all the members agreed to a work program in 1998 and did not agree to mandate negotiations at the December 2017 11th Ministerial Conference in Buenos Aires. And the Marrakesh Agreement also said, if there is to be a plurilateral agreement, an agreement amongst not all of the members, which breaches the fundamental most favored nation rule of the World Trade Organization, there are specific rules that govern plurilateral agreements in Annex 4. And those rules, even though they only apply to a subset of countries, can only be adopted as a WTO agreement by consensus of all the members. Now, the methodology that is proposed to be used for e-commerce, which is to try to bring this in through the back door of schedules to trade and services agreements, not only is contrary to the very clear intention, principles, and rules of the WTO, but is also inconsistent with what the clear objectives and the India-South Africa paper says the proper interpretation of the rules on trade and services. And so what I anticipate is likely to happen is if there is an attempt, for example, to use that services approach, countries who are saying it's unconstitutional will lodge objections to those amendments to those schedules. And there is a process for doing that in the trade and services rules. And then if there is an outcome from that that appears to be going ahead with those schedules, which they say is still inconsistent with the rules, then we may be looking at a dispute that would end up before a panel. and then who knows what the situation with the appellate body will be. So this is the first time this challenge has been articulated in this way. So it's a very important development. And at the General Council meeting last week, when it was on the agenda, the countries that are the proponents of the plurilaterals basically did not engage with any of the arguments. They just said they disagreed.
Thank you very much, Mr. Kelsey. Then we have another question. Although it is somewhat out of context for today's talk, when there is so much of emphasis on the free movement of highly skilled persons, why not there any real emphasis to the movement of unskilled or semi-skilled persons?
Yes, well, that's not really an e-commerce issue, but let me do it in two bites. Obviously, for where you're situated in South Asia, you'll be aware of the India issues with the US, especially on the H-1B visas for IT workers in the US, which was clearly targeted because of the way that it was structured at Indian firms operating within the US and other firms operating within the US who were employing a large number of Indian IT workers. And it really is only firms with over 50 people, 50 employees, half of whom are on H-1B visas, who are caught by that particular rule. And it is hypocrisy in the way that we always see what we call in trade terms mode 4, or the movement of people, that the corporate executives and the professional lawyers and accountants and so on are supposed to be allowed to move in an unfettered way internationally. But when it comes to when there is a competitive advantage from some countries in the South, the barriers go up. When it comes to lesser skilled workers, the barriers are even more so. In the WTO, in theory, movement of natural persons applies to all levels of workers, but because it's governed by the schedule of each country, they've been able to focus on the elite workers. In the bilateral and regional agreements, they redefine the movement of natural persons just to be the elite workers. And that's not going to change, except that China has managed in some of its FTAs to get access for some of its people into employment markets. But that's because China has negotiating leverage. What I think we're going to find becoming a bigger parallel question, though, is that the movement of people isn't, with the growth of back office operations, for example, it is less significant because companies are offshoring into countries that have lower cost but skilled workers that can service operations through digital technologies. So in trade and services speak, we call it mode 1, cross-border supply of services, rather than mode 4, the movement of the people. But even now we're seeing in the US, for example, and in parts of Europe, a backlash against the offshoring. And so this is the way that trade rules work. There is an inherent development asymmetry. The rules are made by powerful countries to suit themselves and their corporations. And developing countries should never have any illusion that playing in that sandpit is going to somehow end up being fair, because that's not the way that they operate. That's why some of the regional initiatives become important, whether it's SADC or some of the arrangements with ASEAN and others that start to make your own rules.
Thank you, Professor Kelsey. Next question. Is it not hypocritical to advocate for digital trade rules without emphasizing taxing income generated by tech companies, particularly on the income generated in the developing countries?
Well, yes, it's hypocritical, but again, it's a question of who makes the rules. And that's why we have been saying, and it worked with RCEP, that it is really important not to tie your hands with those rules. At the same time, we have been, because I said a number of different chapters have impacts in the digital sphere, we have been trying to encourage governments to think of as effective tax exceptions as they possibly can, to ensure that they future-proof the ability to tax whatever new developments, not just what we know now, but whatever new developments might emerge. The best example of that so far that we have is the agreement between Canada and the EU, where it has quite a good tax exception. And I've just finishing now writing a paper for the ASEAN think tank area, which is on digital services taxes in ASEAN and East Asia, which talks a bit about kind of defensive mechanisms. By contrast, the Trans-Pacific Partnership Agreement has the most appalling tax exception. It's described as like one of those Russian dolls where you have a doll inside a doll inside a doll inside a doll. And I did a big report last year on taxing the digital economy and the trade rules. And it's almost impossible to understand what protections that tax exception will or will not create. And so that's why it's incredibly important to be seeking transparency, public access to draft texts, not just by your revenue department, because they're not necessarily going to know all the traps in the trade rules, but by the experts that are external experts who can work with governments to help them understand this. And that's very much what was done in RCEP, even though the chapter wasn't public. Some of the governments there sought advice from experts to help them understand the kind of policy position that they should adopt.
Thank you, Professor Kelsey. Due to time constraint, we will just take one more question. And the last question: are the digital trade rules in some ways a deja vu of the TRIPS?
Yes and no. In fact, one negotiator who was an IP expert said to me that they were concerned that their country was going to make the same mistake that they did with TRIPS, with e-commerce, of adopting rules whose implications they didn't really understand. And by the time they understood them, they were not able to roll them back. And of course, those who know the history of the TRIPS know the role that the lobbyists, whether it was Big Pharma or Hollywood or other of the US and EU and Japanese IP industries played in getting those rules. There is also a very strong analogy with what happened with the entry of the Trade and Services Agreement, the GATS, which was devised by those who described themselves in the US as the GATS mafia, who were looking at ways to facilitate multinationals that needed to move finance and telecoms and people internationally as the multinationals were transnationalizing. And decided that the trade rules, with notions of market access and non-discrimination and removing non-tariff barriers to trade, could be adapted to work for them to remove barriers to services regulation. Why do I say it's not totally like TRIPS? TRIPS was at least contested. There were some big fights over TRIPS, especially by developing countries. And some of the flexibilities that were in TRIPS, not only the phased-in time periods for developing countries and LDCs, but some of the flexibility that existed in the implementation of some of the TRIPS rules was really hard fought for. And that didn't happen with the TPP trade rules. And it's not happening in the text that has just been posted on bilaterals.org, which is the composite text of the e-commerce in the WTO plurilateral. And so that's why there now needs to be much more critical engagement by developing countries in relation to these rules. In the WTO, in terms of the lack of legitimacy of doing this, but also what the risks are, as well as in the bilaterals and regionals. And one last point that I'd make that just kind of illustrates this point is that we understand that the rule on the ability to keep source code secret was deliberately not put in the IP chapter of the TPP, but was put in the e-commerce chapter because the IP negotiators would understand it and would have fought against it. So that was the context of those negotiations.
Thank you very much, Professor Kelsey. It was wonderful having you over, and we certainly look forward to having you even more. Perhaps you could talk about something else and some more interesting topics. And I'd like to bring to your notice that we have a lot of participants who are currently watching this. And for the participants, please do check your chat box. Our technical coordinator has sent you a link of our YouTube channel, and please do subscribe to it because Professor Kelsey's lecture will be available there in a bit. Professor Kelsey, thank you very much. If there's anything you want to say to the listeners, to the people of our country, to the people to the students and the faculty members from North South University and elsewhere, please.
Well, just to thank you again for the opportunity. I won't say it's been a bit talking at you, but at least we did have some talking with you in the questions. And I hope this has inspired you to do some more thinking and discussion amongst yourselves about how you can analyze what this might mean in your context, not just as students and in your courses, but within the country and within the region. So thank you very much to my hosts. and to you for doing the tech work.
Thank you very much, Professor Kelsey. Thank you very much to the listeners. And good night, Professor Kelsey, and have a good day to the listeners.